Lords, I speak to amendments from 152 to 179, which are intended not to undermine but to improve the SSNB. Lords, first a word about collective bargaining relevant to these amendments and to later amendments dealing with that subject. The term was coined by Beatrice Webb in 1891. It means negotiations between one or several trade unions on the one side and one or more employers or employers' associations on the other, with a view to agreeing rates of remuneration and other terms and conditions of employment for a defined group of workers. The term is defined in section 178 of the Trade Union Labour Relations Consolidation Act 1992, which sets out various matters which may form the basis of such negotiations, not just pay terms and conditions, but including dismissals, allocation of work, union facilities, dispute resolution machinery, and so on. The International Labour Organization, ILO, has a similar but less detailed definition in Convention 154. Lords, collective bargaining may be on a sector-wide basis across a particular industry, or it may be confined to a particular enterprise. Where there are sectoral agreements setting minimum terms, they're usually improved upon by enterprise agreements with individual employers in the sector. The UK was the first country in the world to establish widespread collective bargaining coverage. By 1948, the then Prime Minister could say in a broadcast to the nation that, quote, "We have built up in this country a system of collective bargaining without parallel in the world," unquote. That coverage was built upon two pillars: the statutory wages councils introduced by Winston Churchill in the Trade Boards Act of 1909 and latterly regulated by the Wages Council Act of 1979, and the voluntary joint national councils, or Whitley councils, pursuant to the reports of the Reconstruction Committee after the First World War of J.H. Whitley. Governments of all persuasions were committed to the promotion of collective bargaining, particularly because of its very positive effect on productivity in both world wars. In consequence, collective agreement coverage of UK workers was in excess of 80% between 1945 and 1980. Significantly, the proportion of workers covered only by an enterprise-level collective agreement was almost insignificant and had grown to only 9% by the late 1970s. The dismantling of sectoral collective bargaining since 1980 has produced a steady downward curve in the coverage, which was not halted by the introduction of the recognition machinery for enterprise-level bargaining in 2000. The percentage of workers whose terms are negotiated now is likely around 25%. The remaining three-quarters must take what they're offered. The staggering decline from over 80% coverage to 25% has had a devastating effect on workers. The stagnation in the real value of wages, the meteoric rise in zero-hours contracts and in job insecurity can be attributed, at least in part, to that dramatic decline. To achieve the growth and improvement in living standards rightly sought by the government necessitates restoration of extensive collective bargaining coverage. There are considerable benefits. The Canadian Supreme Court a few years ago pointed out that, quote, "The right to bargain collectively with an employer enhances the human dignity, liberty and autonomy of workers by giving them the opportunity to influence the establishment of workplace rules and thereby gain some control over a major aspect of their lives, namely their work. Collective bargaining is not simply an instrument for pursuing external ends, rather it's intrinsically valuable as an experience in self-government. Collective bargaining permits workers to achieve a form of workplace democracy and to ensure the rule of law in the workplace. It's the mode in which employees participate in setting the terms and conditions of employment rather than simply accepting what their employer chooses to give them." End of quote. Whereas workers, of course, also enjoy the benefits of increased wages and improved minimum terms and conditions. Trade unions can negotiate on a sector-wide stage without diminishing their ability to negotiate better terms locally. But the benefits of sectoral collective bargaining extend to employers too. Sectoral collective bargaining prevents undercutting and steadies labour costs. Employers in the same sector must compete instead in investment, innovation, efficiency and productivity, the fields of competition which foster growth. Employers, especially SMEs and micro-employers, also benefit from not having to research or negotiate wages with their workers. Instead, the minimum terms and conditions for their sector are contained in the sectoral agreement. Employers also profit from the increase in consumer demand, consequent on increased earnings generally. Governments enjoy increased tax from higher earnings and the diminished need to fund social security payments to subsidise low wages. Sectoral collective bargaining is proved to reduce inequality, not just between high and low earners, but between women and men, and to reduce the pay gaps suffered by disabled and ethnic minority workers. Lords, there's much research to support these conclusions from academic institutions, but also from the ILO, OECD and IMF. The European Union has gone so far in 2024 as to adopt a directive requiring member states which have less than 80% coverage of collective agreements to put in place an action plan to achieve such coverage. A letter in last week's Financial Times pointed out that in Sweden, notwithstanding its conversion over the last 30 years from neo-socialism to neoliberalism, nevertheless, at the insistence of employers and unions, preserve the very extensive sectoral collective bargaining which characterises Nordic industrial relations. Collective bargaining, and in particular sectoral collective bargaining, is not just desirable in itself, but international law requires the UK to promote and encourage it. That's a subject I'll return to in the next group of amendments. Lords, it's unclear to me why the bill doesn't stipulate the creation of collective bargaining bodies. The long and successful experience in the UK of statutory wages councils and voluntary joint national councils provide fine precedents. There are many other such precedents as well. But with that introduction, I turn to the proposition that the SSNB is not the collective bargaining forum it should be, and which many, unfamiliar with the detail of the bill, assumed it would be. To save time, I shall also refer to the Adult Social Care Negotiating Body. I wish the government had chosen some easier acronyms, since the bill's proposals and the arguments about them are virtually identical. The relevant features are these. 1. The bill expressly states that nothing in the SSNB is to be regarded as collective bargaining as defined by Section 178 of the 1992 Act, and that any agreements reached are not to be regarded as collective agreements. The ASCNB is slightly different in that the relevant minister is given power to exclude the application of Section 178. 2. The bill defines a negotiating body, but its functions do not include negotiation. The parties have no power to decide for themselves the matters they wish to discuss and are confined to the 4 subjects permitted to each by the bill, plus any additions conferred by the minister. The very limited subjects so far permitted exclude, for example, work organisation, diversity and inclusion, eradication of pay gaps, health and safety, deployment of new technology, formulation of a dispute resolution procedure, legal status of workers in the sector. 3. The bill gives the minister power to make regulations as to the nature of the consideration the negotiating body must give to the authorised subjects, with power to direct specific factors the body must take into consideration and any conditions to be met in reaching agreement. For the SSNB, matters can only be discussed by it with the permission of the Minister or on the direction of the Minister, and the Minister can also specify matters which may not be discussed. 4. If the body reaches an agreement, the Minister can override it and require reconsideration, specifying factors which must be taken into account and conditions which must be met in order to reach a reconsidered agreement acceptable to the Minister. Ultimately, the Minister can override agreements of the negotiating body. 5. If the negotiating body fails to agree, the Minister has the power to assume its functions and impose a settlement regardless of the wishes of the parties, who may, of course, prefer their own dispute resolution procedure or conciliation, mediation, or arbitration by a third party in whom they have confidence. 6. Terms agreed and approved by or simply dictated by the Secretary of State will set the terms for all relevant workers. Consequently, any genuine collective agreement for more favourable terms will be void. The effect is that far from promoting collective bargaining, this provision will preclude it. 7. The employers and the unions are unable to decide for themselves the size and composition of the body. That's in the exclusive power of the relevant Minister, who will determine how members may be appointed to each body, including the appointment of a chairperson and third parties who must not represent employers or unions in the sector, with voting rights if the Minister chooses in the case of the ASC-NB, without voting rights in the case of the SSNB. Employers and unions may not choose their own chair, and in the case of the SSNB, must not select one of their representatives as chair, thus precluding a usual arrangement of alternating the chair between the two sides. 8, and finally, the bill defines a social care worker as those employed, thus excluding the many self-employed. Lords, these features are incompatible with free collective bargaining under any definition, and my amendments are intended to do the following. Just take me one moment to go through them. 152, allow the SSNB to collectively bargain any of the matters specified in section 178. 173, allow agreement of the SSNB to constitute collective agreement within the meaning of that section. 153, 160, 162, 167, 170 all provide for inclusion of the self-employed. 154 permits the body to negotiate dispute resolution machinery, grievance and disciplinary procedures, and anything else the employers and unions want to negotiate. 155 to 159 remove the ministerial power to prevent any of the currently permitted matters being discussed. 161 removes the requirement for the Minister to authorise discussion on permitted matters. 163 to 6, 168 to 9, 171 to 2 make the output of the process a minimum floor, thus permitting subsequent or prior agreement for more beneficial terms. 177 remove ministerial representatives and confine membership of the body to unions and employers. 179 permits the SSNB to determine its own constitution, allowing intervention by the Minister only if it can't agree its constitution. I apologise for taking so long, but I now beg to move.